near about claim is near about 26 lakhs. Be as it may, my lord. According to us, there is no such dispute.
Commercial meter or what? Commercial meter?
Commercial meter.
Oh, 10 lakh of rupees.
It's a bulk connection.
Bulk connection. Rice mill.
Bulk connection.
Okay.
Rice mill.
Yes.
Upon petitioners deposited the amount 10 lakhs rupees within a week from date, my lord, page 40. The ordering portion, my lord, I am drawing lordship attention. Upon petition depositing a sum of rupees 10 lakhs within 1 week from date, no quasi action shall be taken from middle portion. I have deposited. Now, my lord, I am challenging the final order.
Why here?
This is not a final order.
Final assessment order?
It is
No, this is not a theft.
Theft. There is no theft. Joseph,
My lord, the earlier order, if your lordship's
now,
kindly
my
go
lord,
through the earlier order, the entire.
Yes. Now, my lord, if your lordship can turn to the ordering portion.
All right.
Internal page 2. Middle portion. Since the meter circuit, my lord, go for the middle portion, my lord will find. Rice mill was defective since 20th January 2024 to 13th March 2024. The meter bearing number such and such is considered as defective. There is no other tools to access the consumption unit in respect of the defective defunct meter other than to depend on regulatory provision. During the defective meter period, consumer has been short billed and the license is entirely entitled to raise the demand. So, in case of escaped assessment. On 14th March 2024, the cause of defectiveness of the meter was removed after rectification in the PT circuit. Hence, the defective period has already been ascertained. So, billing for the consumption of electricity in respect of the defunct meter during the defective period will be done as per clause 3.6 regulation 555. Since the license is certainly entitled to raise demand, installment after observing. Next, the arguments of both the parties that are found that since the metering circuit defective, registration of the meter is considered as defective. There is no other tool to assess the consumption unit. So defective.
Yes, it's the same thing.
Same thing. Now, my positive, what is the course required to be taken? My this clearly came up for consideration before this honorable court. Now, what will be the steps taken for the defunct meter and or which is Sureka Dichi. Sureka. It is further held that even if such a malfunctioning detected, then also the accuracy of the meter should have been tested by placing a check meter in the series of the existing meter for a reasonable period, keeping the complainant informed in conformity with the regulatory provisions, and the meter, if found defective, should have been replaced, subsequently keeping the complainant duly informed, which has not been done. Hence, it is further observed that the action taken with the replacement of the PT circuit of the meter without conducting testing of accuracy of the meter as per regulatory provision are to be considered as unjustified, and in regulatory provision are to be considered in violation of the regulatory provision. Since the LS defective PT circuit has also been replaced, there is no scope for ascertaining the accuracy of the meter at the relevant point of time which is necessitated the regeneration of bills for the said 3 months, which has been disputed by the complaint petition. According to the only logical conclusion which can be drawn, in opinion, the ombudsman is that the WSL failed to establish justification and correctness of the regenerated bills for the period from November 2017 to as per the regulatory provision on the basis of supporting documents. Those bills are therefore be cancelled. So here also, my lord, no steps has been taken, nothing has been done, no check meter has been produced. What is the fault? According to us, my lord, today, my lord, somebody else came and and said this is the defective meter and there is in view of the same. So there must be some provision, the check meter should be there. Same thing, the prior intimation is mandatory. The division bench of this honorable court also held in that line. This is coordinate bench, paragraph 10.
And all those judgment, my lord, they have come up after the ombudsman and regional human rights officer. Here cases differ. Initially, High Court has already entertained the writ petition. That point has not been taken by my learned friends.
1 minute. Paragraph 48 that you relied, and then the accuracy should have been tested by placing a check meter in place of the existing meter. 3.6 regulation, was it taken into consideration by the court in this matter? Sureka?
As your lordship pleases, my lord.
Has it been taken into consideration? 6.8.
3.6.1.
Yes.
My lord, kindly turn to paragraph 5. Raised another bill indicating this is the amount due.
3.6.1 do you have? Please check.
If on inspection by the distribution license or its own or on the basis of complaint of consumer, meter of a consumer is found defective or defunct or for reason other than theft of electricity, as provided in section 135 of the Acts, no theft of energy can be reasonably suspected. The consumer shall pay provisionally for such consumption of electricity for the period during which the meter has been suspected to have been defective or defunct. On the basis of the average consumption and our parameters to the proceedings of the succeeding 3 months during any previous or subsequent thereto may reasonably comparable before the meter has been found to be defective or defunct. If, however, the period during which the meter has been defective or defunct cannot be ascertained, such period shall be limited to a period of 3 months immediately preceding the date of inspection. After that, one can consider 57 also. 55, regulation 55.
This is regulation 55.
Yes, here it says, my lord, can you consider of the regulation is 3.8.3.
No, 3.8.3 is something different. That is, my lord, billing in case unusual variation of the meter. That is different.
That is different. This is defunct meter is 3.6. On 14th March the defect was removed
Yes.
and
So it is
Period has
less
been-
than 2 months, my lord, according to them. Now, my lord, can you turn to page 42?
42. Yes.
Second, the statement of the licensing company, my lord. I'm reading. The meter check against the consumer's check through his portal system for billing month January to March. From 20th January to 13th March and found voltage drop to such and such mention of the Honourable Calcutta High Court directed the meter to pay. The bill imposed.
No, not such and such. That is kindly read it clearly. What such and such? That is the important.
I'm not supposed to answer you.
Potential transformer was.
Wait, please don't interject.
I'm not
Yes.
supposed to answer you.
Yes. Number 2 you were reading.
Consumption is very low.
Huh?
So necessary adjustment unit was given by the for the same month as mentioned as per Honourable such and such.
Yes.
Honourable Calcutta High Court directed to pay 10 lakhs. Well, I am not on that. Billing procedure has been informed detailed to the petition copy regulation 55. Clause as provided. The same was provided to the consumer memo number such and such. After defective meter period continued from 20th January 24 to 13th March 2024. So total adjustment unit is divided into 3 installments starting from the bills number month April to June. No discussion was affected during the intervening period. Now, if your lordship may kindly consider, this is the 3 months bills according to them, my lord. It has been adjusted in 3 months. Prior to that, my lord, if your lordship kindly consider the bills itself.
In such a situation, can you not raise a grievance before the grievance redressal officer?
Yes, that's the law.
He can always apply before the grievance redressal officer.
No,
He cannot.
no, not yet.
So what is to be done?
Yes, my lord. The entire matter has to be decided by the RGRO and then Ombudsman, then before your lords.
This is what the court is inquiring, that he can always raise a grievance before the regional
And
grievance
that is
officer.
the law also. The regulation also, my lord, says.
RGO? Regional office.
No, regional grievance, that is not the grievance redressal officer. The consideration has been done by the officer pursuant to the order of the Honourable.
Right. Now,
Yes.
if he's aggrieved, he can go to the
Yes.
My lord, my lord,
grievance
submit
redressal
to-
officer.
Always.
Whether the regional grievance officer is subordinate or hired to the regional manager.
No, that is different. He is the officer and the grievance redressal officer is
By designation, it should be because the higher authority will adjudicate something rather than the subordinate authority can.
he is the officer of WBSC TCL, but when the grievance redressal officer is he will act on the basis of a particulars notification and particulars power. There is a grievance redressal mechanism. He will have to approach.
But one thing, my lord, may I submit before your lordship, whether the
If I can understand you correctly, the defect period is from 20th of January 24 to 13th of March. The authority could not have calculated any period prior to 20th of January and after 13th March to taking into consideration the bill that has been raised. This is the simple case. Let him raise a grievance.
Yes, yes. I have no difficulties.
Say bills have been raised and you have made payments also.
In terms of the
Court's order.
10 lakhs has been.
10 lakh has
Earlier
been
order
paid.
also.
We have already depositing in that.
Earlier order also that is clear that your lordships kindly have a look, my lord, page 39.
Yes.
The petitioner contends that outstanding dues which are part of the civil suit has been incorporated in subsequent bill. There was a civil suit also in respect of one this meter. This dispute, the civil suit also my lord pending. The petitioner also challenged the methodology.
It has got nothing to do with this.
And we are paying the regular bill above.
Disputed
That
question
is
of
not
facts cannot be gone into by this court. However, the law is clear. The consumer of a bulk supply of electricity has to pay the consumption bill. The regulation also permit the authorities to rectify the bill if such mistake or error is detected. This is my lord, potential transformer has been blown out. As a result, low consumption was shown in the meter. The metering circuit was defective, not meter.
The petitioner is bulk consumer of electricity. It is aggrieved by the order passed by
সেটা বুঝে গেছে